So today, the United States Supreme Court issued a 9-0 unanimous decision that effectively rewrites the rules of engagement between you and the police at your own front door. This isn't just some obscure legal technicality. This is a ruling that affects every single homeowner in America, every gun owner, and anyone who believes their home is their castle. If you think you're safe behind a locked door, you need to pay very close attention to what I'm about to explain. Because as of today, the highest court in the land has clarified exactly when law enforcement can enter your private residence without a warrant, without your permission, and without a judge's oversight. Hit that subscribe button right now and turn on notifications, because the emergency that triggers this power could be a simple phone call from a disgruntled ex-partner or a neighbor with a bad feeling. What happened to William Trevor Case in Montana is now the standard for all 50 states, and it could happen to you tomorrow. To understand why this 9-0 ruling is so explosive, we have to look at the deeply troubling facts of Case vs. Montana. It all started with a phone call, one that many of us have experienced or feared. William Trevor Case, an Army veteran living in Anaconda, Montana, was having a rough night. His ex-girlfriend called 911, reporting that Trevor was acting erratically and had threatened suicide. She claimed she heard a pop over the phone, what she thought was a gunshot, and feared he might also harm any police officers who showed up. Now imagine you are Trevor. You're in your home. You haven't committed a crime. You're in a private mental health crisis. Suddenly, 4 police officers surround your house. For 40 minutes, the officers stood outside. They knocked, they yelled, they shined high-powered flashlights through the windows. Trevor didn't answer. He didn't have to. Under the Fourth Amendment, you have no legal obligation to open your door to the police without a warrant. But inside, the officers saw things that changed everything. An empty handgun holster and a notepad that they assumed was a suicide note. They didn't call a judge for a warrant. They didn't call Trevor's family. Instead, they grabbed ballistic shields, drew their weapons, and walked through his unlocked front door. Minutes later, Trevor emerged from a closet. An officer, claiming he saw a dark object in Trevor's hand, opened fire. Trevor Case was shot in the arm and abdomen. He survived, only to find himself charged with felony assault on a peace officer because of that dark object, which turned out to be a handgun found nearby. This is where the nationwide implications kick in. Trevor's legal team fought this all the way to the Supreme Court, making a fundamental argument. The police violated the Fourth Amendment. They argued that for police to enter a home without a warrant during an emergency, they shouldn't just have a hunch or a bad feeling. They should have probable cause, the same high legal standard required to get a warrant in a criminal case. But the state of Montana argued for something much lower: reasonable suspicion. That's the low-level bar police use to stop and frisk you on a sidewalk. Think about what that means. Reasonable suspicion is what allows an officer to pat you down on a street corner if he thinks you might have a weapon. It's the lowest possible standard in American law enforcement. Montana was essentially arguing that your home, your castle, deserves no more protection than your jacket pocket on a public sidewalk. The Supreme Court had to decide, when the police claim they are helping you, do they still have to respect the moat around your castle? Or does the emergency aid doctrine give them a master key to every home in America? The answer they gave will change how you think about your front door forever. In a rare move of total unity, all 9 justices, from the most conservative to the most liberal, voted to uphold the entry. Justice Elena Kagan authored the opinion, and the message was clear. The police do not need probable cause to enter your home in an emergency. The court reaffirmed the objectively reasonable basis test. This means if a reasonable officer would believe someone inside is seriously injured or imminently threatened with injury, they can bypass the warrant requirement entirely. But here is the cliffhanger that should keep you up at night. Who defines what is reasonable? Is it reasonable to enter a home because an ex-girlfriend who might have a grudge says she's worried? Is it reasonable to enter because you see an empty holster, which is perfectly legal for a gun owner to have? The court just handed law enforcement a massive amount of discretion, and the implications of this decision reach far beyond what happened to Trevor Case in Montana. To understand the gravity of this 9-0 decision, we have to look at the massive legal blunder made by the Montana Supreme Court that forced the U.S. Supreme Court to step in. This is what legal scholars are calling the Montana mistake, and it's the reason your Fourth Amendment rights were just put on a legal tightrope. When this case was first heard in the state of Montana, the state judges did something radical. They ruled that as long as police have reasonable suspicion, that low-level hunch we talked about, they can enter a home to prevent a suicide or a shooting. The U.S. Supreme Court saw this and hit the panic button. Why? Because if the Supreme Court had allowed the reasonable suspicion standard to stand, the Fourth Amendment would have effectively been deleted from the doorway of every house in America. Justice Elena Kagan, writing for the Unanimous Court, had to perform a delicate legal surgery. She had to slap down Montana's low bar standard while still giving police the power to enter homes in a crisis. The result is a refined standard called the objectively reasonable basis. It sounds like a win for privacy, but for the average homeowner, it's a legal minefield. Here is where the script gets dangerous for you. The court ruled that the entry into Trevor Case's home was objectively reasonable. But let's look at what the police actually knew versus what they imagined. Fact 1, an ex-girlfriend called. Was she reliable? The police didn't know. Fact 2, she heard a pop on the phone. Could it have been a dropped plate, a car backfiring, a TV? Fact 3, they saw an empty holster. In Montana, and most of the US, owning a holster is not a crime. The Supreme Court decided that when you add these three things together, it creates a reasonable basis to enter. But here is the kicker. The court said it doesn't matter if the police were wrong. Under this 9-0 ruling, as long as an objective officer could interpret the scene as an emergency, the entry is legal even if there is no actual emergency. If the police break down your door because they reasonably thought you were in danger, and it turns out you were just taking a nap with your headphones on, you cannot sue them for a civil rights violation. They are protected. This is the qualified immunity shadow that looms over this entire ruling. If you are a gun owner, this section should make the hair on your arms stand up. The Supreme Court specifically pointed to the empty handgun holster seen through the window as a key factor that made the police entry reasonable. Think about that. The mere sight of a legal accessory for a constitutionally protected item was used as a justification to bypass the warrant requirement. This creates a terrifying precedent for the millions of Americans who keep firearms for self-defense. If a police officer peers through your window during a welfare check and sees a box of ammunition on a table, a gun cleaning kit, or a tactical vest hanging on a chair, does that now give them the objectively reasonable basis to kick in your door? According to the logic in this 9-0 ruling, it certainly contributes to it. The court is essentially saying that the presence of a firearm, even the hint of a firearm, increases the emergency level of a situation, thereby decreasing your Fourth Amendment protections. For years, police have tried to use a legal loophole called the community caretaking doctrine. This was originally designed for police to check on abandoned cars on the side of the highway. Over time, aggressive prosecutors have tried to expand this doctrine to include your home. In this decision, the Supreme Court finally drew a line in the sand, but it's a thin one. They explicitly rejected the idea that community caretaking allows police to enter a home for general safety reasons. They said no, the home is special. However, they immediately replaced it with a beefed-up emergency aid exception. So while they closed one door called community caretaking, they opened a massive window called emergency aid. The police just have to change the words they use in their reports. Instead of saying we were performing a community caretake, they will now say, based on the totality of the circumstances, we had an objectively reasonable basis to believe an emergency was imminent. It's a linguistic shift that leads to the same result: police in your living room without a warrant. Perhaps the most chilling part of this ruling is how the court viewed Trevor Case's silence. Trevor did what many constitutional auditors and legal experts suggest. He didn't engage. He didn't shout back. He remained silent in his home. He exercised his right to be let alone. But the Supreme Court used that silence against him. The justices noted that because the police yelled and knocked for 40 minutes and received no response, it was reasonable for them to assume he was dead, dying, or lying in wait to ambush them. This creates a catch-22 for every American. If you talk to the police, you might incriminate yourself. If you remain silent, your silence becomes the emergency that justifies them breaking down your door. You are now in a position where your exercise of the Fifth Amendment right to silence can be used to destroy your Fourth Amendment right to privacy. This is a constitutional paradox that the Founding Fathers never could have imagined, and it places every American in an impossible position when police arrive at their door. This 9-0 ruling doesn't exist in a vacuum. It has arrived at the exact moment that red flag laws or extreme risk protection orders are sweeping across the country. Currently, 21 states and D.C. have laws that allow the government to temporarily seize firearms from individuals deemed a danger to themselves or others. Usually, a red flag seizure requires a petitioner to go before a judge and present evidence. But after today's Supreme Court decision, the police have a backdoor. Think about the logic the court just validated. If police have an objectively reasonable basis to believe there is an emergency, they can enter the home. Once they are inside legally under the emergency aid exception, anything they see in plain view is fair game. If they enter your home on a welfare check because a neighbor called in a bad feeling, and they see your rifle case or your handgun on the nightstand, they can seize those weapons under the guise of public safety or securing the scene. They don't need the red flag warrant anymore because they are already inside. They've bypassed the judicial process entirely. This ruling effectively weaponizes the welfare check to serve as a warrantless search for gun owners. The statistics here are staggering. According to the National Institute of Mental Health, 1 in 5 American adults lives with a mental health condition. That is 50 million people. Under this new unanimous standard, a history of mental health struggles combined with a vague report from a third party could be enough to justify a warrantless entry. Justice Jackson, in her concurring opinion, noted that the Fourth Amendment shouldn't force police to stand by and do nothing. But the flip side is a world where millions of Americans are one concerned phone call away from a tactical team entering their bedroom. This creates a massive chilling effect. If you are a veteran or a gun owner struggling with your mental health, are you going to seek help? Or are you going to stay silent, knowing that a therapist's report or a family member's call could lead to the Supreme Court-sanctioned breach and clear of your front door? We're creating a system where the people who most need help are the ones most afraid to seek it, because seeking help could result in armed officers breaking into their homes. Make no mistake, every law enforcement agency in the country is reading this 9-0 decision today. For the last several years, many departments have been hesitant to enter homes during mental health calls because of the fear of lawsuits. That fear is gone. This ruling provides a good faith shield for officers. Training protocols will be updated immediately. Officers will be taught that they don't need to wait for a supervisor or a warrant if they can articulate specific facts, like the empty holster in the Trevor case that suggest an imminent threat. We are likely to see an immediate spike in warrantless home entries nationwide. This isn't speculation. This is how law enforcement agencies respond to Supreme Court decisions that expand their authority. Prosecutors will use this ruling to unsuppress evidence in thousands of pending cases where lower courts had previously ruled the police overstepped. If you had a case thrown out last month because of an illegal entry, don't be surprised if the district attorney tries to bring it back to life tomorrow. Defense attorneys across America are scrambling right now to understand how this decision impacts their clients. So, what do? If the Supreme Court has ruled that silence is suspicious and entry is easy, how do you protect your castle? The legal landscape has shifted, and your tactics must shift with it. Here is the reality. If you stay silent and the police have a reason to be there, they are coming in. If you open the door, you have consented to the interaction and given them a clear line of sight into your home. The middle ground. You must communicate through the door without opening it. First, state your status clearly. I am safe, I am alone, and I do not require assistance. Second, explicitly deny consent. I do not consent to a search or entry of my home. Third, ask for the reasonable basis. What is the specific emergency you are investigating? By speaking through the door, you break the silence is suspicion trap. You are providing evidence that you are not incapacitated. If they still choose to enter after you have clearly stated you are safe, their objectively reasonable basis becomes much harder to defend in a later court hearing. Document everything. If you have a doorbell camera or security system, make sure it's recording. If you don't, consider getting one. The only way to challenge an unlawful entry later is with evidence of what was said and done. Record the interaction from your side of the door if possible. Note the time, the officer's statements, and your responses. This documentation could be the difference between winning and losing if this ends up in court. Understand that this advice exists in a legal gray area that the Supreme Court has now made even grayer. The court has essentially said that officers can make mistakes in good faith and still be protected, but creating a clear record of your cooperation and your explicit refusal of consent gives you the best possible position if you need to challenge the entry later. It shows that you were not in distress, that you communicated clearly, and that any decision to enter was made despite your explicit statements of safety. For over 200 years, the American legal system has held that the poorest man may in his cottage bid defiance to all the forces of the crown. Today, the Supreme Court didn't destroy that cottage, but they certainly took the hinges off the door. By a vote of 9-0, they decided that safety and reasonableness outweigh the absolute sanctity of your private residence. William Trevor Case was shot in his own home after doing nothing more than being silent. The Supreme Court just told the world that the police were right to be there. This is the new reality of the Fourth Amendment in 2026. What do you think? Is this a necessary tool for police to save lives during suicide attempts and domestic violence calls? Or is this the final nail in the coffin for the sanctity of the home? Drop a comment below. I read every single one. And this is a conversation we need to have as a community. This ruling is going to have ripple effects for decades. The balance between public safety and individual liberty has been recalibrated, and we're all going to live with the consequences. If you found this breakdown valuable, please hit the like button and share this video. Most people have no idea their rights were just redefined by a 9-0 vote, and word of mouth is the only way to keep our community informed. If you want to see the full text of Justice Kagan's opinion or the concurrence warnings from Justice Jackson, I've linked them in the description below. This is information that every homeowner, every gun owner, and every American needs to understand. Your front door is no longer the impenetrable barrier it once was, and knowledge is now your best defense. Stay vigilant, stay informed, and most importantly, stay safe. Know your rights, even as they change. Understand the new rules of engagement. And remember that in America, the law is only as strong as the citizens who understand and defend it. Thanks for watching, and I'll see you in the next one.